Hello, welcome everyone to our fourth and final presentation in our 2021 Commercial Network webinar series. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we've got a great presentation lined up to discuss how last year's U.S. Supreme Court decision in the case McGirt and versus Oklahoma could impact the title insurance industry. Before starting, I always need to go through our housekeeping items. Everyone's lines are muted for today's discussion. If you have a question, please submit them to the questions box. We'll try and hold a little time for Q&A at the end of the presentation. Today's webinar is being recorded and will be available on ALTA's website at alta.org/webinars. That's alta.org/webinars. Tomorrow, you'll also get a follow-up email with a link to the recording. You can download a copy of today's presentation from the handout section in the Go to Webinar window pane. It should be noted that today's webinar does offer CE and CLE credit in many states. Credit is only available to those attending this live presentation. To meet compliance with state requirements, we'll have some poll questions. Make sure everyone out there is paying attention. And then at the end of the presentation, I'll post a link in the chat box. That way you can provide the information we need to report your CE or CLE credit. If you have any questions about that, shoot us an email at education@alta.org. I do need to thank Dell Technologies for sponsoring today's Commercial Network webinar. And before introducing the speakers, I have a short message from Dell to play.
We started with computers. We didn't stop at computers. We didn't stop at storage. We didn't stop at cloud. We didn't stop at wholly integrated intergalactic solutions. We kept going, working with our customers to enable the kind of technology that can guide an astronaut back to safety, or help make a hospital come to you instead of you going to it. And we didn't stop there. We're even working to make packaging that comes from waste instead of producing it. Because we saw a world that was full of challenges and ready for solutions. So when it comes to your business, you know we'll stop at nothing.
All right, thank you, Dell. Right now, I'll introduce today's speakers, and we'll get into the meat of the presentation. Joining us today, we have Megan Powell. Megan is commercial underwriter with First American Title Insurance Company, and we also have Dan Buchanan. Dan is senior title counsel for First American, and both Megan and Dan serve on ALTA's Native American Lands Work Group. And with that, Megan, I'll turn the presentation over to you, and let me give you the keys here real quick. There we go.
Okay. Can you see my screen effectively?
We can. We're all good to go.
Great. Well, I'm going to go ahead and turn off my camera here to lessen the distraction a little. Well, thank you, Jeremy. It's a pleasure for us to be here virtually to provide some content on McGirt, as well as our title insurance industry's response to that opinion. So the agenda for the presentation is displayed on this slide. And I'm going to start things off by talking about McGirt and relevant underwriting concerns associated with insuring on Native American lands, primarily focused on McGirt. And then Dan will address the new ALTA policy forms that were created largely in response to the McGirt decision. And I would also like to quickly note that the ALTA Native American Lands Work Group has created several webinars that are recorded and available. I think the website is alta.org/education/webinars. Maybe that's the site that this webinar will be on as well. So if you want more education on Native American lands, that's where you can go to find those presentations. Okay, so let's start with some history on Native American land holdings in Oklahoma. Due to the Indian Removal Act of 1830, the US government relocated several tribes from their homelands in the eastern part of the United States, including what were referred to at the time as the 5 civilized tribes. So those tribes are the Cherokee, the Muscogee, Creek, which by the way, they have recently dropped Creek from their name, so I'll just refer to them as Muscogee going forward. The Seminole, the Chickasaw, and the Choctaw. They were forced to march over 2,000 miles across 9 states to the new Indian Territory, which is now Oklahoma. At the time, they were calling it Indian Territory. And over half of the Muscogee and Cherokee populations died during that march, which most people historically know as the Trail of Tears. The General Allotment Act, passed by Congress in 1887, which is often referred to as the Dawes Act, authorized the allotment of parcels of reservation land, usually between 40 and 160 acres, and they were allotted to individual tribal members. After that allotment process was completed, surplus land was often purchased from the tribes, and then it was sold to non-Native Americans. There was also a variety of amendments to the General Allotment Act, creating other avenues for taking allotment parcels out of restricted status, which means they could be sold or taxed, and then subsequently lost to tax foreclosure. So the individual tribal member who previously owned their land in trust status or in restricted status weren't being taxed. And then once it comes out of that restricted status and they start being taxed, they don't realize or understand, or at the time historically they didn't, that they needed to pay those taxes or they would lose their ownership in that property. So a lot of property was lost that way, in addition to the sale of surplus lands. So much Native American land was lost as a result of the General Allotment Act that the allotment process was finally terminated in 1934 by the passage of the Indian Reorganization Act. In 1889, 2 million acres in western Oklahoma were redesignated as unassigned lands and open to white settlement. And then not long after that, the Curtis Act of 1898 abolished tribal courts and subjected all persons in Indian Territory to federal law, which prevented enforcement of tribal laws and legislation. So for several years, tribes were stripped of land, governmental authority, they were subject to assimilation tactics. But finally, in 1975, Congress passed the Indian Self-Determination and Assistance Act. And that act effectively revived tribal governments by rejecting formerly suppressive policies. It was kind of a change in attitude and approach towards tribes by the federal government. And today, there are 39 tribes and associated tribal governments in Oklahoma that are recognized by the federal government. So there's a bit of history for you. So now let's talk about the McGirt case and its impacts on the industry. Whenever I talk about this case, I always like to include this quote in my presentation because I think it's very impactful. I have listened to other people that are Native American speak on this case that have talked about this quote being impactful. It's a quote from the opinion, which was authored by Justice Gorsuch. And I just want to note that tribes frequently litigate over rights granted to them in their treaties with the federal government. And to me, this quote demonstrates how powerful a treaty is as a contract between the tribe and the United States, because that's really what treaties are. They're contracts. Okay, so McGirt. McGirt decision was issued by the US Supreme Court on July 9th, 2020. So we're over a year out from it now. Jim C. McGirt is an enrolled member of the Seminole Nation. he was convicted of a sex crime in Oklahoma State Court. And he argued that because he had committed his crime on an Indian reservation and he's Native American, he should have been tried in federal court pursuant to the Federal Major Crimes Act. So he essentially was saying the state has no jurisdiction over his case. The state responded to that by saying that the Muscogee reservation had been disestablished many years ago. So basically saying, no, you didn't commit your crime on a reservation because there's no reservation there anymore. So ultimately, the court ruled that the Muscogee reservation was established in 1833 by a treaty, which was modified by a subsequent 1866 treaty, but the reservation was never disestablished. So a lot of people initially panicked and thought, oh, well, if the reservation is there, then the tribe owns all of that land. And that's not the case. It doesn't mean that the tribe was awarded the land in fee. It just means that all of the land within the original boundaries of the reservation was confirmed to still be within a reservation, despite the fact that everyone in the state of Oklahoma hadn't treated this land as reservation land for years. The Muscogee reservation is about 3 million acres, and it includes, like you'll see on the slide here, most of the city of Tulsa. So it's not just touching residential property, it's impactful on commercial properties as well. So this decision in McGirt confirmed the existence of the Muscogee reservation. However, the rest of the 5 civilized tribes also benefit from the McGirt decision because of their similar historical treatment and treaty rights. So the decision is widely considered to confirm establishment of 5 reservations rather than 1. So you'll see I have a map on the slide there showing the reservation lands of the 5 civilized tribes. All of these reservations are in eastern Oklahoma, and the Osage Reservation, which was established pre-McGirt, is also in eastern Oklahoma. You can't see it on this map, but the Osage Reservation is immediately west of the Cherokee Reservation and north of the Muscogee Reservation. So with all 6 of those reservations now confirmed intact reservations, there's about 19 million acres of established reservation land covering the eastern half of Oklahoma. So the McGirt decision wasn't really just a win for the Muscogee tribe. It was a win for all of the 5 civilized tribes, and all of this reservation land that you see in red on the slide here was considered not to be reservation land until July 9th, 2020, when essentially overnight they received that, confirmation. So the McGirt decision caused a flurry of activity pertaining to criminal cases involving Native Americans, and still is. However, it also created significant confusion regarding jurisdiction over land inside the reservation. So over a year after the decision, we're still grappling with questions pertaining to jurisdiction, applicable law, possibility of tribal compacting. So let's examine some of those issues and some of these questions on the slide a little bit further. If you've ever listened to me talk about Native American lands in general before, you've probably seen this slide. I use it a lot in presentations to just drive the point home that tribes are sovereign nations. So they have inherent tribal powers, which include the ability to form their own government, the ability to create their own laws, regulate land use, and also create their own tribal court system. These laws, regulations, judicial systems, they're applicable to lands over which the tribes have jurisdiction. Some tribes have more developed tribal governments than others. Some, have judicial systems that are more sophisticated than others. So we've got 574 tribes that are federally recognized in the United States. And I also like to make the point that if you research one tribe and their law and their government and their judicial system, you still got 573 to go. I mean, they're not, it's not a scenario where you figure out one and you've figured out all the rest. They're all independent sovereign nations with their own set of laws and structure in their government. So it's critically important to understand how title to property is vested when considering who has jurisdiction over that property. So I'm going to go over these three types of vestings that are identified at the top of the slide. Vesting in fee title is what we're used to working with on a daily basis. So when we're talking about Native American lands, we often use the term unrestricted fee, which means that the owner of that title can sell, mortgage, lease, or encumber that property without any sort of restriction. Restricted fee lands are typically allotment parcels. I talked about allotments earlier when we were talking about the Dawes Act. And those parcels have deeds that have verbiage on them that says the property cannot be sold or encumbered without approval from the federal government. And then we've got trust land, and trust land is land where title is vested in the United States of America in trust for a tribe or for an individual Native American. So the grantee clause in the deed will say United States of America in trust for the Choctaw Nation or something like that. Tribes have both regulatory and judicial jurisdiction over property vested in trust and restricted fee when they're inside the boundaries of a reservation. And a tribe may or may not assert jurisdiction over land owned in unrestricted fee inside the reservation. And I realize that's confusing and seems ambiguous, but it's a tribe to tribe thing. So some tribes may say, well, this is our reservation, and so we are asserting that we have jurisdiction over all lands inside this reservation, regardless of ownership. And then other tribes might say, well, we are concerning ourselves with the trust and restricted fee parcels inside our reservation, and property that's owned in unrestricted fee, we're not asserting jurisdiction over. So it really comes down to what the tribe is asserting. Whether or not they can assert jurisdiction may depend on, well, number one, what they believe they're entitled to, as well as case law. So if there's ambiguity as to who has jurisdiction, sometimes a tribe and a state or local government will enter into a tribal compact, which is essentially an agreement as to who has jurisdiction over what. So if you're insuring inside the boundaries of a reservation, it's important to understand who has jurisdiction so you can determine what laws and regulations are applicable to that land when you're issuing a policy and underwriting the risk that you're covering in that policy. So there was a reference a few slides back to the Montana case and the need to consider what impact it has on jurisdiction. Montana case is an important case pertaining to regulatory authority of non-Native Americans on fee land inside the boundaries of the reservation. It says that right on the slide there. So in the Montana case, the court created a two-part test for determining jurisdiction. If the non-tribal member has consensual relations with the tribe, such as contracts or leasing, the tribe can assert jurisdiction over the non-tribal member. Also, if the non-tribal member's conduct threatens or has some direct effect on the political integrity, economic security, or health and welfare of the tribe may assert jurisdiction over the non-tribal member. So those two exceptions are commonly known as the Montana exception. So you might hear somebody say when they're talking about jurisdiction that tribal law is applicable, or you may need to consider the Montana exception, and that case is what they're referring to. So it's really challenging for title insurers because the part especially that pertains to contracting with a tribe or its members, trying to drill down on exactly what that means. So for example, if two neighbors sign a shared driveway easement for their property, and both their properties are inside the reservation, and one is a tribal member, is that a contract that would invoke tribal jurisdiction under Montana? Those are the kinds of questions that we, have to ask ourselves when we're insuring inside the boundaries of a reservation. And you may not always know, because you don't always know if insured or an adjacent landowner is Native American. So, understanding what law is applicable to the land you're insuring, it's not just limited to regulations. What about foreclosure law, mechanics lien law? If you're insuring a construction loan inside the boundaries of a reservation, do you need to examine the tribal code and see if they have mechanics lien law? Maybe not, if it's fee land and the tribe isn't asserting jurisdiction over the fee land. But if it's trust land, then you definitely should. What do you apply statutes of the state or tribal code? What if you're asked to issue a zoning endorsement? Can you issue a zoning endorsement without knowing whether the tribe's zoning ordinance is applicable to that land? Those are some of the crucial considerations when underwriting a transaction on Native American lands that weren't present really in Eastern Oklahoma until the McGirt decision. So, as soon as the McGirt decision was entered, kind of overnight, we're forced to start thinking about these things when insuring in Eastern Oklahoma, because there's so much reservation land there now. So the impact of McGirt extends far beyond just the state of Oklahoma. Native American tribes that are engaged in some kind of dispute or litigation pertaining to tribal jurisdiction or reservation boundaries may ask the court to consider this precedent established by the McGirt decision. So we've already seen this approach in the cases identified on this slide, and those involve tribes in Washington, Michigan, Minnesota, and Wisconsin. Just want to give some recent updates related to McGirt. There's been a lot of activity lately, so I'll give you some highlights. The first one is the Yakima Nation in Washington State, and they have been litigating with Klickitat County since 2018 over a tract of land that is 121,000 acres that they refer to as Tract D. The tribe claims that Tract D falls within their reservation boundaries, but the county disagrees. So like I said, this litigation started in 2018, so it's been ongoing since well before the McGirt decision. The tribe won in U.S. District Court and recently again in the U.S. Court of Appeals for the Ninth Circuit. So the county has to decide now if they want to appeal to the United States Supreme Court. The Yakima Nation was one of the first tribes to call another court's attention to the McGirt decision during this boundary dispute. So when they were still in litigation in the Court of Appeals, they actually sent a letter to the court with a copy of the McGirt decision attached and asked the court to file it on the docket in the case and to consider the precedent established by McGirt. So that was one dispute right away where we saw a request for the court to invoke McGirt. There was another case that I don't have referenced on this slide, but it involved the Oneida tribe in Wisconsin, and there was a dispute over whether or not a reservation had been disestablished there, and very shortly after McGirt, the court found in favor of the tribe, citing McGirt in their decision as the precedent. So let's see, the Bossy case. Bossy is an individual who was convicted of murder in Oklahoma. He actually himself is not Native American, but his victims were, and his crime was committed on the Chickasaw Reservation. The Oklahoma Court of Criminal Appeals threw out Bossy's murder conviction based on the McGirt decision, which means he would have to be retried by federal prosecutors. And the Oklahoma Attorney General's office sought review from the U.S. Supreme Court with an argument that the state shared jurisdiction because Bossy isn't a Native American. the state was also arguing that the McGirt case was just wrongly decided in general and should be overturned. But just last month, on August 12th, the Oklahoma Court of Criminal Appeals reversed itself in a case called State v. Wallace, which is also referenced on the slide, by ruling that the McGirt decision is not retroactive and that it can't be raised by individuals whose convictions became final when they lost their case. So this is another murder case. This crime was committed on the Choctaw Reservation by a Native American. The lower court had vacated the conviction based on McGirt. So this case will undoubtedly go up to the Supreme Court. So as a result of the decision in State v. Wallace, Bossy's conviction was reinstated, which removed the grounds for the AG's petition to the Supreme Court. And because of that, the petition related to the Bossy case was withdrawn, but it remains to be seen what happens with the retroactive argument in the US Supreme Court. And of course, that argument is being made in a criminal case, but if it's determined that McGirt is not retroactive, it could be a good sign for our industry that, we don't have to worry about how we underwrote policies before McGirt without realizing that we were insuring on Native American reservation land. But it's not an absolute, but it would be comforting if there was a Supreme Court decision that clarified that McGirt was not retroactive. Let's see. And then the reference to the Oklahoma v. DOI case involves the Office of Surface Mining. The state filed that case in mid-July in response to a ruling from the Office of Surface Mining that stripped the state of its authority over surface coal mining on reservation land. And that ruling is specific to the Muscogee Reservation, but like McGirt, it would be applicable to all reservation lands of the 5 civilized tribes. So, it's not really impactful directly to the title industry, but just interesting to watch because that industry, the oil, gas, and mineral industry, is very concerned about the McGirt decision, and there's been a lot of angst and emotion over that decision. So this lawsuit isn't too surprising because they don't want to lose, their authority to mine on reservation land, which cover half the state. So any attack on McGirt, even if it's not directly from our industry, is something that we want to pay attention to because the ripple effect could, impact us in the long run, even if we're not directly affected by that litigation. So, and I think we've reached our first poll question, which you can see on the screen. And Jeremy, do you want to launch that? Looks like maybe you already did.
Yep, got it, Megan. Interesting to hear about the ramifications of the case on these different cases. And I actually had a quick question when you were talking about if you're handling a transaction with a shared driveway in a reservation. How would a title agent find out if one of the homeowners is Native American? I mean, can't you ask that, or is there a place, a resource where the title agent would know to go to?
Well, most companies, our company, Dan and I work for the same company, we don't ask our customers whether they're Native American or really anything about their ethnic background.
Right.
And so you wouldn't really know. It would probably have to be something that was disclosed to you. But when you're inside the boundaries of a reservation, it might be something that you consider in terms of the coverage that you're willing to give, knowing what you don't know. Okay. So you're basically saying, well, I don't know if these individuals are Native American or not, and I'm not going to ask them. But by not asking and giving the coverage, I'm assuming this risk. So, you have to ask yourself if you want to give the coverage or not in light of that risk.
Okay, all right, thanks. Yeah, we're going to close the first poll and make sure everyone out there is you want CE, CLE, and make sure you're paying attention out there. We'll close this, and we'll get back to the presentation.
Do you share results?
We can. So it's 41% on the presentation have not handled transactions involving Native American land. 24% less than 5, 11% 5 to 10, and a quarter of the people who took the poll said they've handled more than 10. So interesting though, 40% have not.
Well, I'm glad you're attending.
Right, that's right.
Okay. So I'm going to hand the presentation over to Dan Buchanan now, who will address the new ALTA forms that are created in response to McGirt.
Thanks, Megan. That's an interesting poll result. I wonder how many of the 41% have actually insured a transaction on Native American land without realizing it. Anybody operating in eastern Oklahoma, whether they knew it or not, and that's really the fundamental impact of the McGirt decision, what we sometimes refer to as the McGirt surprise. For years, companies have insured property that's within the boundaries of a reservation, sometimes very deliberately with a very intentional approach to how they structure their coverage and underwrite the risks involved in operating within what it amounts to a foreign jurisdiction, another country almost. But the real impact or lesson of McGirt is that you may not always know that you are within the boundaries of a reservation, and that was pretty eye-opening. One of the first things that we started talking about following the McGirt decision, and I mean first thing like on July 9th of 2020, many of us spent most of that day talking about the potential ramifications. And one of the things that we took a look at was our existing policy forms. So Megan, let's move to the next slide. And like most contracts, our policies identify a choice of law and venue provision where we try to provide for a contractual agreement as to what the applicable law is in interpreting our policy and enforcing the terms of our policy. And you'll see highlighted on the screen our existing policy language in the 06 policy forms says that our policies should be governed by the law of the jurisdiction where the land is located. Well, if you're within the boundaries of a Native American reservation, what is the jurisdiction where your land is located? It's not much of a stretch to recognize that that jurisdiction could certainly be interpreted as being tribal jurisdiction. And I can tell you that's not what the industry intended in the creation of our policy forms. It was not jurisdiction where the land is located became, I think, more of a shorthand for the state where the land is located, or the District of Columbia, or Puerto Rico, or the U.S. Virgin Islands, any of the territories where we insure. So we recognized right away that we had some issues to deal with. Next slide, Megan. So the first opportunity that the ALTA Forms Committee had to discuss this issue resulted in the Forms Committee creating what we called an operative law subcommittee. I was privileged to be able to chair that subcommittee and serve on that subcommittee. And our first assignment was to try and manage our risk under current policy forms. There wasn't much we could do about the policies that we've already issued, although we did spend some time thinking about what kind of risk we might have in our book of business. But the first thing we could really deal with is until new policy forms were adopted, what should we do with the 2006 policy forms? And it was very clear that one of the things that we needed to do was address that choice of law and form provision. And the result is the ALTA 47 series of endorsements and addendum, which is what we'll go through now. The other thing that we recognized is that we needed to go back to the drawing board a bit on the 2021 policy forms. You might recall that by July of 2020, ALTA Board of Governors had already approved a new policy, owner policy and loan policy form, and it was available for public comment. It was a long public comment period. It was designed to run through the end of 2020. So there was no final version, but there was a board adopted version of the owner and loan policy forms. And so another task of the operative law subcommittee was to go through those forms and figure out what we needed to do to address the McGirt issue, the jurisdictional issues in those forms as well. So let's talk a little bit about the ALTA 47 series. And basically, the way we approached it is we created some new defined terms by adding some terminology to the existing conditions through an endorsement. We revised the choice of law and forum provision, and we added some exclusions to coverage to the policies, again, through the use of these endorsements. There was an endorsement created for each policy form, and for the short form loan policy versions that don't use endorsements, we created addendums to go with those. And the reason for that is to be able to match up the numbering system, to add a definition to condition 1 of the policy with the right numbering system, to have the exclusions have the right number, which is why you have a 47, a 47.1, a 47.2, a 47.3, et cetera. The first thing we did is create a new defined term, and in the ALTA 47 endorsements, the defined term is state, both with a capital S and a lowercase s. And the reason for that is that while defined terms are normally noted with an uppercase initial cap, the policy already used the term state in a number of locations in a lowercase form, and we wanted the definition to apply to those references as well. And so the defined term of state is the state or commonwealth within whose exterior boundaries the land is located, and also includes the District of Columbia, Commonwealth of Puerto Rico, the Virgin Islands, and Guam. What the term state does not include is a Native American tribe or reservation. We also included a defined term of tribe. You can see it there. It's a state or federally recognized tribe, band, nation, community that enjoys a government-to-government relationship with the United States or a state. We wanted to capture both federally recognized tribes as well as those that are state recognized. Now, using the defined terms, we then addressed the choice of law provision. And you'll now see where it's highlighted that now instead of referring to the jurisdiction where the land is located, we now talk about the law of the state and to the extent it controls federal law, and then we also address the choice of forum, indicating that a litigation concerning the policy may only be filed in a state court or a U.S. federal court having jurisdiction. And we specifically said that when applying conflict of law principles, a court should not apply the law of a tribe. Let's go on to the next section. And one of the things that you may have seen if you saw one of the initial versions of the ALTA 47 endorsements, then when they were first posted for public comment, was a provision in it that specifically referenced exclusions 1 and 2 and noted that those exclusions apply to tribes, laws, ordinances, governmental regulations, governmental police powers, and power of eminent domain. We initially thought it might be helpful to specifically note that our existing governmental exclusions would cover tribal governments the same as any other state or federal government. Based on some feedback and our own deliberation, we decided that that was unnecessary, that it was very clear based on the definition of tribe as being a governmental entity with a government-to-government relationship, that it was very clear that that would fall within the tribal laws and ordinances and regulations would fall within our existing governmental police power and regulation exclusions. And so we deleted that. So if you were familiar with the original version or the public comment version of the ALTA 47, you will not see any reference to the governmental exclusions in the final version, in the version that became final as of April 2nd. All right. We also thought it was appropriate to add an exclusion to the policy through the use of the endorsement. And this exclusion addresses tribal records. For those of you that have experience insuring within reservation boundaries, it is sometimes very difficult to identify where appropriate records are stored or to even get access to records concerning Native American lands and associated documents. And so this exclusion addresses any defect, lien, adverse claim that might arise from something that does not appear in the public record, meaning the records under state law that impart constructive notice, but might be disclosed by an examination of records maintained by or on behalf of a tribe or on behalf of its members. So with respect to loan policies, we also added an exclusion for any loss that would arise based on the application of tribal law because the insured mortgage failed to specify state law as the governing law with respect to the lien of the insured mortgage. Now, why did we think that was necessary? Well, interestingly, we started also looking at mortgages and discovered that the standard uniform instrument used by Fannie and Freddie and frankly, almost all institutional lenders said the same thing our policy did. It said that the choice of law for the enforcement of the mortgage was the law of the jurisdiction where the land is located. And we believe that it was appropriate to encourage lenders to make the same sort of changes to their loan documentation that we were making to our policy forms through these endorsements. And I'll give you an example of why. We spent some time looking at the Muscogee tribal ordinances, and the Muscogee tribe has a very extensive ordinance with respect to foreclosures. And it's a little unclear as to how they intend to apply that in this new McGirt era, but it reads very broadly, and it says, in essence, that any foreclosure must be a judicial foreclosure conducted in tribal court, and at the conclusion of the foreclosure, the property may only be disposed of by the lender to a tribal member or the tribe. Now, we don't know if on unrestricted fee land, if the tribe will attempt to assert, or individuals will attempt to assert, that foreclosures are only valid if they are conducted in tribal court, and that any foreclosed property must be offered to the tribe or a tribal member, but there is certainly that risk. And so the choice of law provision becomes very important. Under the Montana case that Megan discussed, one of the two Montana exceptions is that consent exception. And if you have a contract that consensually chooses the jurisdiction of the tribe, then you may be bound by those tribal ordinances, even if they might not otherwise be applicable. And so since pointing this out, both Fannie and Freddie have authorized their loan originators to specify state law as opposed to law of the jurisdiction in their mortgages. But we thought it was important to address that issue through this exclusion in our ALTA 47 series as well. Next slide. It's important to note that the exclusions in the ALTA 47 endorsements are contained in section 3, and you will see that they are in brackets. And if you're familiar with how ALTA structures its policy forms, language that's in brackets is optional. It's intended to be used or deleted based on the direction or requirements of the member company that is issuing the policy. So the idea behind this was we can add these exclusions in brackets to the endorsements if the risk can be underwritten, if we can either access tribal records that might affect the title, or we know that there aren't tribal records affecting the title, we can delete the tribal record exclusion. If the mortgage that we're insuring has an appropriate choice of law provision, we can delete the exclusion related to the mortgage's choice of law provision. So that was the reason for bracketing those provisions. The ALTA 47 series is designed for use with the 2006 policy forms. They are not intended to be used with the 2021 policy forms that are now final and are in the process of being filed or promulgated or loaded into transaction systems and vendor software and all of that. And I explained already why we have a different form of ALTA 47 for each of the different policy forms. If you look at the ALTA 47 designed for use with the homeowner policy, you'll notice that the language is a little different. It's a little more consistent with the plain language aspect of the homeowner policy. And as I indicated, addendums are used with short form policies as opposed to an endorsement. So the other thing that the Operative Law Subcommittee did was address the 2021 policy forms. And the concepts that we carried forward was the definition of state. So state is now a defined term in the 2021 policy forms. The choice of law and form provision has been appropriately revised. What we did not carry forward into the 2021 policy forms is any reference to tribes. We thought that it wasn't really appropriate to specifically address Native American tribes in these new policy forms. The ALTA 47 series really is intended to be used only when the property is either within the boundaries of a reservation or might be within the boundaries of a reservation. I know that's kind of a weird concept, but as Megan pointed out, we are seeing cases around the country, not just in Oklahoma, in other states, where tribes are either asserting the reestablishment of a reservation where maybe one was thought not to have existed any longer, or to expand boundaries of a reservation that have been diminished over time, but not in accordance with the standards set by McGirt. And so identifying those areas is a bit tricky, but the 47 series is really intended to be used where the property is or may be within the boundaries of a reservation, not just as a broad brush. And so we did not carry forward that same specific, references to tribes or the exclusions. We didn't bring forward any exclusions. If you are within a reservation and you're using the 2021 policy forms, if you can't underwrite tribal record risks, it will require a Schedule B exception of some type. Similarly, if you've got a mortgage that is problematic in its choice of law, you might want a separate Schedule B exception in the policy. But we didn't think it was appropriate to just add those kinds of broad exclusions to policies that will be used even when there are no Native American land issues at all in play. We also, in addition to simply making these operative law changes to the policy forms, we took a look at all of the ALTA endorsements. Many of the endorsements were modified because they use the term state. and we wanted to use the capitalized term because it is now a defined term under the policy. In some cases, we added a reference to state where it might have otherwise said applicable law, for example. And we also made a fair number of what you might call substantive changes. And I'll give you a few examples as we wrap up here. Zoning endorsements. Megan mentioned zoning as an issue. We recognize right away that there could be a conflict between tribal zoning ordinances and local zoning ordinances. And unless we deliberately underwrite to tribal zoning ordinances, we want to make sure that when we refer to zoning, we're talking about the type of zoning that we have historically underwritten to, meaning state, county, or city. You know, the local zoning ordinances established under state law. Same with subdivision law. Those of you that insure construction loans and use the ALTA 32 series will see that we specifically modified the language of the ALTA 32 to make clear that when we talk about coverage for mechanic liens, we're talking about mechanic liens that are arising under state law. And so you'll see a number of endorsements. I think we ended up in the 2021 policy form package revising about 30 endorsements. Not all of those were operative law changes, but most of them were. And so those adjustments have been made. The sooner you can transition to the 2021 policy forms and endorsement forms, the better off you will be in terms of being prepared for dealing with the McGirt surprise when you find out you insured something that is within a reservation boundary. That's not to say that you can simply use a 2021 policy form and insure property within a reservation without thinking further about it. Anytime you're insuring within the boundaries of a reservation, for all the reasons Megan discussed, requires very careful deliberation and collaboration with your underwriters. And with that, I think we're at our final poll question.
Yes, we are. Megan and Dan, before I launch this, thanks for walking us through the history of the Native American lands, impact of the McGirt ruling, and also all the great info on the ALTA 47 series and the new 2021 policy form. So this question, for people who are paying attention still, obviously a generic question, but did you know that ALTA just published the 2021 policy forms? And Dan, thank you for all the policy form committee's work in getting all that together. A few more seconds here, get to answer the poll question. 92% said yes so far, 8% no. So, all right, we'll close the poll. I have posted the link in the chat box, the SurveyMonkey link. So if you need CE, CLE, please click that link and get us the information that we need to apply for your credits. We do have a few questions come in so far already. And Megan and Dan, I know we're almost at the top of the hour, but maybe we can do, I can pitch a couple of them to you real quick, and then if we don't get to your question, as you can see on the screen, both Megan's and Dan's emails are there. You can please feel free to reach out to either of them. Megan, I think you were talking about the McGirt case and about whether it be retroactive. Geraldine asked, would enforcement of previously issued policies default to the local, county, state level, or does the default exist only if McGirt is determined to have been retroactive.
So I just want to make sure I understand the question. Is it if we had default in terms of what law is being applied?
I'm going to go with yes. It's not in the question, but yeah.
Okay. Well, I'll respond, and hopefully my answer will be responsive. And if not, please drop me an email so I can clarify.
She said yes.
Okay. So, the point that I was trying to make is the policies that have been issued up until the McGirt decision were issued and underwritten based on the assumption that the law of the jurisdiction where the land is located, remember Dan showed that language on his slide, would be, state or local jurisdiction because of the assumption that there was no reservation there. And so if it is determined that McGirt cannot be applied retroactively, then the hope is that that would not solely be applied to criminal matters, but to all matters that are impacted by McGirt, so that we can address, reservation, jurisdiction on reservation as of July 9th, 2020 forward, and not worry that our entire back book of policies may have been underwritten and issued without considering the law of the jurisdiction where the land is located potentially being tribal law. So that would be the benefit of a determination that McGirt is not retroactive. Unless that determination is made, then we still have that outstanding question as to, well, did all of these policies that get issued pre-McGirt take into consideration the law of the jurisdiction where the land is located, possibly being tribal law? And, in most cases, I would say no, because nobody thought that the reservation was still intact.
Okay. All right. So stay tuned. Quick question about FERPTA and whether or not this applies to tribes that are recognized as sovereign nations. So does FERPTA apply here?
If the question is, would FERPTA apply to property owned by a tribe where the tribe is disposing of it, I think the answer is no. Tribes are, as a sovereign, generally speaking, tax exempt. There is a lot of pending controversy around the issue of taxation of tribes for property that they own outside of a reservation, where they own property in fee that is not held in trust by the United States. But that's a whole different issue. And in most of those cases, and Megan can correct me if I'm wrong, but I think in most of those cases they are holding title in domestic corporations, either tribal corporations or state chartered corporations or other entities that are generally, exempt from withholding as well.
Well, it sounds like FERPTA is another opportunity for a webinar later date. All right, we're almost 5 minutes. 2 quick questions, Dan, if you don't mind, on policy forms. One is in the 2021 ALTA policies, the word state lowercase sometimes appears as state capitalized, utilizing the defined term, but in other places appears as state lowercase. Is this intentional or is it a typo?
It is intentional. You will typically see the word state capitalized if it relates to coverage, because we want to be very specific that we're talking about the particular state where the property is located. In other instances, state will be lowercase, where it could be any state. and potentially even be applied to a tribe. For example, there might be a business entity that owns property in one state, but has filed bankruptcy in the state where they're incorporated. In that case, that state would be lowercase s. The state where the property is located is the capitalized S. So that was a long-winded way of saying, yes, that is deliberate. State with a lowercase is intended to be broader and not necessarily limited to the state where the property is located.
Oh, okay, interesting. And capital S to specific states such as Oklahoma. Yeah. And then one quick question as far as usage of the new 2021 forms and the 06 policy forms. I believe, maybe and probably I'm wrong. Companies could still use the 06 form if they wish, or will it eventually be decertified?
The intent is for the 06 policy forms to be replaced with the 2021 policy forms, but we recognize that that is sometimes a fairly long process. Between the regulatory issues of state filings and things like that, plus getting them implemented into our transaction systems and just general customer acceptance takes some time. The Board of Governors has identified the decertification date for the 06 policy forms as the end of next year. So there's about an 18-month period before the 06 policy forms are formally decertified by ALTA. But in the meantime, companies can elect to switch quickly over to the 21 forms, continue to use the 06 policy forms, but there is an expectation that there is a transition period where you will probably be working with both sets of forms for some time.
Yeah, definitely a process over the next year. Have a few more questions about policy forms, but we're going to have to wrap up today. We'll have more opportunities to discuss the forms themselves and reaction from customers here in the coming months. And I believe there'll probably be an ALTA Forms session at ALTA One in New Orleans next month.
There will be, yes.
Yep.
There's also a recorded presentation on the 2021 policy forms that was done by Paul Hammond and Jim Gosden that should be available on the ALTA website.
Yeah, they are. It is alta.org/webinars, and we do plan on doing another one in December. Just keep it front and center of everyone. It is the main product of the industry and very important updates to let everyone know that they're available. Again, if you missed parts of today's webinar, I think others in your office would benefit from listening. You'll get a link tomorrow with a link to the recording. And as we mentioned, all of our webinars are archived at alta.org/webinars. Before wrapping up, I do need to thank Dell once again for sponsoring today's presentation. And we mentioned New Orleans. We'll have there's a track dedicated to commercial transactions at ALTA One. I will also say, I know maybe it's on your minds with the hurricane that went through New Orleans. Obviously, we're still dealing with surge in COVID cases. We are monitoring both fronts. We just got word today that the hotel is running 100% right now. They're in good shape. So we don't see any problems there for next month. As far as COVID, we've implemented several protocols to keep everyone safe. At the end of the day, that is our first priority. We all know the joy and the benefits of being together and networking, together, but we also at the same time want to be safe and be cautious and be mindful for everyone's health and safety. having said that, we're monitoring what's happening in New Orleans. The city does have a vaccination and mask mandate, and if anything changes, we'll communicate that information to everyone who's interested in attending and those who have already registered. And with that, Megan and Dan, thank you again for sharing your expertise on Native American lands and the forms.
Thank you for having us.
Welcome.
All right, and that will conclude today's presentation. Take care, everyone.
Thanks all.
Thank you.